and we will go through the main principles and cases that you should be aware of for revising this topic. Patents are registrable rights one is able to gain over the creation of an invention, or the requirements of the Patent Act 1977 shall be met for the product to be able to get patent protection. Therefore, in a problem question about patents, you need to apply Patents Act 1977. The main sections that you will need to apply is section 1, 2, 3, and 4. You need to discuss each of them in turn and make sure that you analyze if all the requirements set out in Patents Act 1977 are met, and also any relevant cases that would qualify the interpretation of the Act would need to be mentioned. Now we will go through each of the requirements that Patent Act contains. Firstly, invention shall be new. Section 2. Patent novelty, person skilled in the art test must be applied. Person skilled in the art test is clarified further in cases, and you will need to know the relevant cases for person skilled in the art test, apply it to the facts of the case, and provide correct analysis. Thirdly, inventive steps. An invention must involve an inventive step if it's not obvious to a person skilled in the art having regard to any matter which forms part of the state. Therefore, in the opinion of a person skilled in the art, the invention has to have inventive step. Industrial application. This is the easiest requirement that most of the patent applications will satisfy. Industrial application requirement. This is when invention is capable of basically commercialization. Most of the inventions that apply for patents are capable of commercialization. Therefore, industrial application requirements should be satisfied too. Subject matter of patent. Unlike copyright, when we're looking at Patent Act, one does not find a complete and closed list of what can be considered patentable. So for copyright, we have a list of certain intellectual properties that can attract copyright protection. Whereas for patents, it's not the same approach. We do not have a closed list of intellectual properties that are recognized to have a right to be patentable. Instead, the legislation only declares certain things as not inventions. So as long as a patentable work can avoid being pigeonholed into one of these categories, it will likely to earn patent. So as long as you can successfully apply the requirements of the patent as set out in Patents Act section 1, 2, 3, and 4, you should be able to argue in your case that the patent is or is not met. Now we're going to dive into the discussion of what are the requirements for an invention to be patentable. A discovery, these are the inventions that cannot be patentable, such as discovery, scientific theory, or mathematical method, a literary, dramatic, musical, or artistic work, a scheme, rule, or method for performing a mental art, playing a game, or doing business, or a program for a computer. The presentation of information, such as like if it's a scientific discovery that can be very valuable for betterment of our lives, it cannot be patented and it should be available to the public. And similarly for the other rules, these are the areas that it's not in the interest of the public for the patent to be granted. UK has a technical approach, which basically means that it excludes technical contributions that reside in the excluded categories. Therefore, it has to be something of an innovation, something that is not merely a technical effect of already existing discovery. Industrial application set out in section 4. An invention shall be taken to be capable of industrial application if it can be made or used in any kind of industry, including agriculture, which basically means that it has to be capable of commercial application. Novelty requirement. Novelty requirement is a key feature in the requirement one needs to fulfill to gain a patent is to have the invention to be new and not anticipated. This is done to make sure patents are not granted to the expense of an industry and people already working in it. It also just makes sense to have a blanket requirement of novelty. Patents would be an entirely different beast if the requirement for an invention was not for it to be newly invented. So it has to be some kind of a new invention rather than an addition to the existing one, because the patent cannot be granted at the expense of the industry. Inventive step, section 3. An invention shall be taken to involve an inventive step if it is not obvious to a person skilled in the art having regard to any matter which forms part of the state of the art by virtue of only section 2 and above disregarding section 3. Therefore, for the application of section 3, we need to apply the person skilled in the art test. And person skilled in the art test was clarified in case law. This is more subjective and qualitative way than the approach that novelty takes. Novelty is a system of quantifying the extent the prior arts reach into a newly filed invention and making a judgment on if it satisfies their threshold, while inventive step asks for the invention to be obvious. So the main takeaway from this principle is that it has to be obvious to a person skilled in the art, not to reasonable people. A person has to be skilled in the art. And it has to be, the invention has to be obvious to the person skilled in the art. And the case that has further clarified this test was Pfizer Ltd's patent. The hypothetically skilled person in the art is not a real person, so they do not have to actually bring an expert on the court for a patent to be granted. It's just a hypothetical person who is skilled in the relevant area where the patent is sought. The person needs to be able to understand and have read all available documents in the prior arts and have no biases. So someone hypothetical who is impartial, has all the relevant knowledge, does not have any biases, should be able to decide that this is an invention and it should be obvious. It should not be hard to see. The whole point behind the person skilled in the arts test is to create a sense of objectiveness in the subjective test of obviousness, providing a baseline. So in other words, it's an objective test, but it is also subjective because it depends on the opinion of a person skilled in the art. But since this person skilled in the art is a hypothetical person who is impartial and has all the relevant knowledge, can be argued that this is an objective requirement. Issues with patents. If you have an essay question on patents, there are several issues that you should consider. Most of the cases have challenges as to interpreting the novelty requirement. It's not easy to interpret what is obvious to a person skilled in the art, and many patents fail to satisfy this requirement. So this challenge of the patent law does need considerable discussion if you have an essay question on patents. And also, one more interesting thing about the law on patent is that it comes into contradiction to a well-established competition law principle against creation of monopolies. This can be something to be explored if you have a question that requires critical analysis of the laws on patent, because the companies cannot cannot have a monopoly in the industry, whereas patent grants them a monopoly, and they will be the only people who can commercialize the product that is patented. Therefore, it kind of comes into contradiction, and this is an area that deserves attention. Suggested reading after the session would be to have a look at our notes, example essays. We have example essays for intellectual property law of high to 1 and first class level, and I highly recommend you to have a look at them to see how you should approach a problem and essay question in this topic. We also have case summaries that you can have a look. This is available for free, case summaries. We have some tutorial videos you can have a look. We have quizzes and flashcards to practice. We cover UK intellectual property law as well as international one. So you can have a look at all the study materials that we have in this topic and the links below. You will receive the slides as well as the recording of this session after it's finished. Now I would like to briefly talk about how we can help you with intellectual property law. At Simple Studying, we have simple study resources made by top students and graduates that can help you maximize your chances of getting high grades, because all our materials focuses on teaching the students the easiest way to get high grades. If the resources are not enough, we have an additional service, tutoring services, which is a one-to-one personalized help with the tutor to discuss anything that you may be struggling with. Can be help to prepare for your exam, or help to even proofread the assignments or plan your assignments, anything that you may need help with. It's a Zoom session, one-to-one, and you can book it via this link. We have already helped thousands of law students to get high grades, and we would like you to be our next student to be successful. Thank you very much for attending this session, and we would like to encourage you to join Simple Studying now. Thank you.